Not to say that the defendants would be entitled to start manufacturing and importing and they cannot be detained or enjoined from infringing the standard essential patent, but more from the objective of trying to come at an interim royalty rate kind of arrangement. It could be in the form of a bank guarantee. It could be just identifying the interim FRAND determination that has been done by the courts. There hasn't been so much of an analysis on what should be the FRAND terms. It's pretty much adopted what the other companies have been doing worldwide by assigning a FRAND term or royalty based on not on the chipset or not on the technology per se, but the value of the handset. But the four things are the rulings of the standard essential patent litigation is one, patent hold-ups, that whether that should be permitted or not permitted, and what are patent hold-ups? Patent hold-ups are essentially when there is a crucial technology, you lock in that technology, and without that technology you cannot work the invention, or work any mobile handset or any telecom related invention. As a result of which you can ask for exorbitant royalty rates. So that's one determination that did arise before the CCI, that's the Competition Commission of India. The second was patent stacking or royalty stacking, what we call as royalty stacking when there are multiple patents. So you start aggregating the royalties on a multi-component technology and ask for exorbitant rates. The third thing that evolved, and maybe that's going to be a separate topic, is the role of experts. So in the Ringo case, that was the first case in the telecom sector where before the single judge, when it was at the interim stage, one of the experts was not considered as being an expert because he did not have those specialized qualifications in the area of telecom. Subsequently, obviously, it was vacated, but there's been an extensive discussion on who an expert would be for any patent litigation. As a result of this kind of a decision of the courts, scientific advisors, after many, many years, we do have a provision under the Indian patent law on scientific advisors. It's being used, I think the first case that I remember over the last 5 years was the Bayer case for Nexavar. It was a pharmaceutical case. It was the first time in the telecom sector that the court decided to appoint 3 scientific advisors from IITs and several other independent institutes to be able to assist the court in explaining the technology. And the last thing that came up was the royalty base. What would be the correct selection of royalty if the litigation or the infringement action relates to standard essential patents? Would it be based on the chipset, which is going into the technology, or would it be based on the value of the handset? So this is a kind of a very the conflicting views. You have divergent views on this. There's some people who say that even if it's 1,000 rupees phone, why should you be paying why would you be paying royalty on 1,000 rupees? You might as well just pay, because that's not. The technology is not adding to the value of the handset. But at the interim stage, the courts did come up and say, as of now, we're not doing that FRAND determination. It's going to be decided at the trial stage. So let's keep that aside and let's start adopting as an interim arrangement, start depositing royalty based upon the value of the handset. Now, this was what's happening at the High Court. Now, in the meanwhile, because they're all related to standard essential patents, I think the only thing that emerges is that the owner has to give a license at a reason, the FRAND terms. And that's the reason why it resulted in actions going down to the CCI, the Competition Commission of India. So when the Competition Commission of India in the Micromax, and I think there's another action where against Ericsson, when they did go before the Competition Commission of India, the CCI started dwelling into the issues of FRAND determination as to whether Ericsson is abusing the dominant position, and to assess whether Ericsson has a dominant position. They kind of outline four parameters. The 4 parameters being that how many patents do they control in that space, the conduct, issues like why do you want to have an NDA before you disclose the patents that cover a standard, some issues of this nature. And while they were about to adjudicate, I would say adjudicate upon the FRAND terms, there was a writ petition that was filed by Erickson before the Delhi High Court. That's when the High Court kind of interfered and said that the CCI really doesn't have the jurisdiction to start determining what the stand is, and to that extent they should just do a very preliminary determination whether there has been an abuse of dominant position by Erickson and leave it to the Delhi High Court, or not the Delhi High Court, the High Courts of the country to decide what the FRAND terms ought to be, what would they be, and that would be decided after a trial. So pretty much this is what, in a nutshell, this is what the overview of the entire litigation that's happening in the country on essential patents. But I would just touch on a very, very small issue, and maybe we could discuss this subsequently in our panel discussion, is we have often spoken about multiplicity of proceedings, and when we do talk about multiplicity of proceedings, the first thing that comes to our mind is, you know what, the Patent Act provides for oppositions, it provides for pre-post invalidations before the High Court, invalidations before even the IPAB, that's the Intellectual Property Act of Court. But if you just take a step back and look at the litigation, that's the dispute in the Erickson and the Ringo cases, I would imagine that when there are multiplicity of proceedings, you would also kind of look at the interface between the proceeded infringement actions before a High Court and the determination of abuse of dominant position by CCI, because that would be pretty much an overlap of the issues that will be finally adjudicated in all of these SAP litigation. So maybe we could just discuss this when we come to that, but I thought I can make this flag position because CCI has only interfered not so much in the pharma cases, but more in the telecom domain.
Thank you, Archana. Just one query. When this was litigated, was the patent validity was in question? And this is interesting because this is standard essential patent. So one has to prove indirectly whether somebody is infringing. First, whether the patent is reading onto the standards and are they implementing the standards in their handsets. So can you throw some light on this?
I think what we come down to is there are two aspects. One is obviously establishing infringement at the very interim stage, and the other is whether there has been a prima facie challenge to the validity of a patent so as to disentitle the plaintiffs, or for this in these cases Erickson or Ringo, from being entitled to an interim injunction. Now when we look at these two issues, unlike pharma cases, I wouldn't kind of club them all together. Unlike pharma cases, when we are looking at the telecom sector, by just seeing the technology, it's very difficult to establish infringement. You just cannot establish infringement by saying, I have a patent here, these are the 4 steps of the implementation of the method, or if it's an apparatus or a device, and this is all there in the handset or on the infringing device. It's not possible. So obviously that's when the role of experts comes into play, and that's maybe one of the reasons why the interim injunctions were vacated very quickly, and the courts came up to an interim finding that let's have an interim arrangement, have a bank guarantee, or have a royalty payment. So that's when you have to, I would imagine that you would have to establish infringement either through affidavits, where if it's a standard essential patent, you read a claim on a standard, a document, and if that implementation is then read through on the infringing device. So that's when you have to establish infringement. It's not easy to prove, for in the area of the domain that we're talking about, ICT. It's not easy. But when we talk about invalidity, whether there has been a prima facie challenge, I think in few of the cases, I don't recall all of the cases, there have been actions, a counterclaim for invalidation. There have been revocations that have been filed in the Ericsson cases before the Intellectual Property Act Board. And interestingly, obviously, there are defenses for invalidity that have been taken up in the infringement action. What then emerges is that if you are, how would the defendants establish non-infringement? So we can establish infringement, we can knock out patents on invalidity, on that it's an invalid patent, but if it is a standard essential patent and if the infringing device is in compliance with a particular standard, it's going to be difficult for a defendant to establish that they're not infringing. So non-infringement does not really become a big defense for an SCP patent if it has been declared as a standard by SSOs or standard setting authorities. A better defense is an invalidation defense. So it's like my infringement report or technical report versus a defense of invalidation. Not so much a defense of non-infringement.
In the same context, India, they notified in 2007 IPR imports or border protection, which is popularly known. In that context also the same patents were registered by Ericsson. And in that context also it was litigated whether particularly the customs has the jurisdictions to decide whether the patent is valid, and second is that whether they can decide whether the imported goods are infringing or not.
I think that's the third dimension, so maybe it kind of slipped my mind that when we are talking about this multiplicity of proceedings, it just need not be about patents and invalidation of patents. We've got several ways to stop the infringing goods from being sold into the Indian market. So be it through a complaint before the CCI, or is it if it's a product infringing device that's being imported into the country, you can just register your patent with the customs authorities and under the border enforcement rules, and you can just have all those infringing devices seized. And then you also have I wouldn't say a fallback position. That's actually the border security enforcement rules. The border enforcement rules is your fallback position, and your main action will still be trying to obtain an interim injunction, at least a preliminary injunction from the high courts. So I think all these three actions, all these three forums have a very active role to play, and it has to be a correct, appropriate selection of which one of these would you want to adopt when you are kind of trying to dwell into these or deciding issues of whether to litigate or not to litigate a patent. But yes, it's only confined. I'm just talking about standard essential patents. When it comes to non-standard essential patents, maybe the parameters and the yardsticks to establish infringement, to take a defense of non-infringement, or kind of challenge the validity of the patent would kind of be treated very differently from a standard essential patent.
Thank you. Stephen, would you like to say something on the same subject? What happens in the UK or Germany or Europe otherwise?
Thank you. As far as the UK and more broadly Europe is concerned, issues like this tend to be fall within the ambit, so to speak, of competition law authorities in the European Union, and there are several sort of decisions in recent times that are sort of relevant. There's the Motorola decision and the Motorola case and the Samsung case. In the Motorola case, there were the patent infringement proceedings in Germany in relation to Motorola seeking to prohibit the online sale of Apple devices, and that gave rise to an injunction. And then there was a reference to the European Union. As a consequence of which, it was found that the holder of a standard essential patent, if they committed to license those patents and to do so on FRA&D terms, then it was nonetheless an anti-competitive position to exclude a competitor if that competitor was prepared to take a license on those terms. And in relation to the point you make, that Archand made in relation to validity, it was considered that if you are in a position where you're seeking as a patentee to apply for an injunction at that time, then that would distort and render the negotiations as being distorted, and that then comes into broad consideration as to imposing unfair license terms based on that distortion. That then is bad for the public interest due to distortion of prices, and that then leads into some of the broad prohibitions and cornerstone questions, cornerstone principles of the European Union of not having distorted markets. So it was found that that if you effectively seek to prohibit a willing licensee from entering the market on appropriate terms, then you would be in breach of competition rules. And another aspect of that is that you essentially be in a position where you're seeking to extract license revenues from a third party for patents which may be invalid or which may not be infringed. So there was also consideration of prohibition of settlement in the settlement terms on any sort of issue. Prohibition on a challenge of the validity of the patent was itself an anti-competitive issue. So there was therefore there's a requirement that the third parties need still be free to challenge the validity of a patent, even when taken under those terms. In the Samsung case, there were provisions that a mechanism was set out that provided for negotiation over a 12-month period between the parties to reach an accommodation settlement on free, reasonable and non-discriminatory terms. And in the event that position could not be resolved, the matter would then be transferred to a third-party arbitrator to essentially come to a view on that, to then settle the matter. As regards the European position generally, the European landscape, I think the principles in these and other cases are, whilst they be developed in relation to sort of the telecoms and sort of electronics sector, I think they're broad-based principles that we see being applied across all technology sectors. Just sort of coming on to the multi-jurisdictional sort of questions. In the European Union, we have, as you will be aware, the unitary patent and the unified patent court is due to come on stream in present best estimates from those people who are closest to the proceedings are that it is likely to come into being in early to mid 2017. This raises further interesting questions for patentees as to whether there is what is the best approach if one wishes to enforce patents between looking at the GIPC route, looking at differences between Germany, France, Italy, the UK, and then within the UK there are multiple tracks that you can take as well. There's the patent court, conventional proceedings. We also have the intellectual property enterprise court, which is for small scale litigation and where there are low values, but nonetheless there are certain advantages to that, not least of which is speed and limitations on costs, and also patent office proceedings. want to go into a little more detail on those at the moment, or leave that for a moment. So there's at the moment a very active sort of landscape. We've got changing, shifting standards, and the interaction between the national proceedings, the GIPC, and then we also have always the European Patent Office opposition proceedings interacting with those, are making for sort of interesting times with regard to the whole prospects of litigation, issues related to certainty or uncertainty, questions relating to timing and costs. For example, in the High Court, there have been cases in the High Court with full trial, which have been heard within 7 months from proceedings being issued. I was involved in a case some years ago where we issued proceedings in July, and we had a full trial purely on declaration of infringement and certain limited validity issues within 5 months, and that's in the High Court. As compared to, for example, the European Patent Office, where one can often expect rarely less than 3 years, and often significantly long periods before you can get an initial determination on validity. And then when you align that together with the position in other countries, it's very complex landscape. And the UPC has the intent, part of the intention of the UPC is to try to remove some of these wrinkles. Whether or not that will in fact happen remains to be seen. We'll talk about that in more detail later.
Before I go to the second question to you, I would like to address the second question to Stephen. Particularly in the Europe, how do you see the forum biases? Are there any differences within the Europe if you have a choice to choose between the different forums?
Yes, that's always one of the fundamental considerations when it comes to enforcement of patents in Europe is which country, what is the timing, the relative timing is between countries. At the moment I have a matter where we have European Patent Office opposition proceedings, UK litigation where we have a fast-track timetable in the Intellectual Property Enterprise Court. There's also German national proceedings, and there are a whole host of considerations which have led to this complex position. And so the question as to where one wishes to enforce a patent is based on consideration of cost, the speed of the proceedings. As I mentioned, you might, for example, find that you have a high-quality judgment coming out of a German court which allows you, the patentee, to go to the German court without fear of the patent being challenged as regards validity, purely because the patent is under opposition proceedings in the EPO. It would not be possible to challenge validity in Germany whilst there are pending opposition proceedings. So a would-be infringer can simply be faced with the position of having to defend an infringement action, and it may be that their position is of not disputing that they're falling within the claims, but simply that the claims are